This is the people of the state of Colorado versus James Egan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. Rather than keep the jury waiting, I think what makes the most sense is to have them go to lunch. We were planning on taking a lunch break anyway. Have them go to lunch, then we'll come back. We'll do the prosecution's closing argument. We'll take a break. We'll do the defense's closing argument, take a break, and do the prosecution's rebuttal at that point. I'm going to need a little more time. There are a lot of slides or a lot of objections, and I need to review them. And if I decide that any slides need to be modified, that's going to take the prosecution some time as well. So I'm thinking it's almost 12 right now. I'll bring the jury in and see how late they can stay today, and then we'll go from there. Okay? Let's bring the jury in, please.
Judge.
Please be seated, everyone. The record should reflect that the jury's back in the courtroom. Folks, thank you very much for your patience. There are some things that I need to talk to the lawyers about outside your presence still. And rather than keep you waiting, it occurred to me that it makes more sense to have you go to lunch, and then when you come back from lunch, we'll proceed. The question then is, how long do we take for lunch? And that depends on how late you can stay today. If we take an hour lunch, I could have you back by 1, and then 4 hours of closings would take us to right about 5. But then when you include the couple of breaks in there, it'll take us beyond 5. So to be safe, is there anyone here who is not able to stay as late as 6 tonight? Is there anyone on the jury who's not able to stay as late as 6 if necessary? Anyone? Okay, no one's raising their hand. All right, and I'm assuming everyone's willing to do it, and everybody's saying yes. Okay, great. I appreciate that. I'm not saying that we're going to stay till 6, but just in case. What I'm going to do then is give you a lunch break until 1 o'clock, and then hope that at 1 o'clock when you come back, we're ready to go, and we're ready to start with the first closing argument, which is the prosecution's closing argument. All right? During the lunch break, you need to make sure that you abide by all my admonishments. Please leave your instructions or your copy of the instructions and your copy of the sample verdict forms on your chair. I've given you the law that you're to apply in this case. And by the way, there was a question from you, and I think that my instructions answer that question, but the lawyers will also get to comment on the instructions during their closing argument. You may be tempted to want to start thinking about the case and forming opinions about the case. You need to resist that temptation. You cannot do that until I tell you that you can start deliberating, and that won't be until after closing arguments. Does everyone understand that? And everyone's saying yes and nodding their head yes. All right, enjoy your lunch, and I'll see you back here at 1. Please be seated, everyone. what I propose, folks, is to give me another 15 minutes or so. Let me get through the slides and through the cases that were cited, and then I'll try to come out around 12:15, 12:20, give you my rulings, and then that hopefully still gives you about a half hour or so for lunch and to make any changes that need to be made. All right?
Yes, sir. Yes, Your Honor, and I had one argument that briefly that I wanted to add, which was the slides that talk about, look how smart, how philosophical I am, etc., highlight the defendant's decision and right not to testify under the Fifth Amendment and the Colorado Constitution, Article 2, Section 18.
Okay, thank you. All right, the court will be in recess. Thank you.
Please rise.
Back on the record, this is the people of the state of Colorado versus James Egan Holmes, case number 12-CR-1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. In the brief amount of time I had, I did my best to look at the slides in the prosecution's closing argument, or the ones that the prosecution intends to use in closing arguments, and then I also looked at some of the authorities cited by the defense. So let me first talk about in Ray Glassman, 286 Pacific 3rd, 673. This is a Washington Supreme Court case from 2012. And again, the record should reflect that I am limited in the amount of time that I have to get this done based on when the objections are being raised and based on when the parties exchanged PowerPoint presentations. So this is not my doing, this is the parties' doing. I encourage them to do this. The parties are indicating that they only had them ready this morning when they showed up to court. So that's when they exchanged them. That's up to them. That's not up to me. In terms of Glassman, this is a case from the Washington Supreme Court. It is not binding on this court, but I found it to be helpful reading. I don't find it to be applicable in general. It is a case that includes what I would describe as egregious conduct by a prosecutor. And without getting into detail, a lot of detail, in that case, the prosecutor used a PowerPoint presentation that included altering some of the exhibits that had been admitted into evidence by adding a caption, his own caption of what he believed the exhibit demonstrated, or his own opinion in the caption. Of particular concern to the court was a picture that showed the defendant and the prosecution added a picture or a caption that said, "Do you believe him?" There was another slide where the prosecution added the caption, "Why should you believe anything he says about the assault?" There was another caption that showed the defendant and the victim, and this was apparently a domestic violence type case based on what I could gather from my quick reading of the case. And then there was a caption added to that photograph as well, something like "the end of our love" or something like that. And I am paraphrasing because I can't find that specific quote right now. Perhaps most concerning to the court was a slide where the prosecution added the words "guilty, guilty, guilty" as a caption to a picture of the defendant, and the words were all in red. And the court mentioned how red is the color of blood, and that based on all these captions, that the jury was likely inflamed. The court explained that a prosecutor could not stand up in closing argument and just start yelling, "The defendant is guilty, guilty, guilty." And the court then concluded that just as the prosecutor could not do that, the prosecutor also should not be allowed to add a caption to an exhibit that was admitted when the caption was not part of the evidence. And the court stated that the picture as admitted did not have the words "guilty, guilty, guilty" on it. So I think that case is different than what we're dealing with here, but I did find it helpful. I also read People versus McBride and People versus Summers. These two cases have to do with comments in closing arguments and the prosecutors can make with respect to defense experts. And it's not as simple as saying, well, Your Honor, the prosecution can't say anything negative about our experts because that's denigrating our experts. It's more complicated than that. But the prosecution also has to be careful because it is not a situation where there are no limits. There are limits. So in the McBride case, which is cited at 228 Pacific 3rd 216, that's a Colorado Court of Appeals case from 2009, the court indicated that the prosecution made repeated personal attacks on a defense expert who had relied on crime scene evidence to offer an opinion. The prosecutor in closing argument said, or referred to the expert as the hired gun expert, and stated that the hired gun expert had come up with something. And experts aren't going to just admit to you that they made this up. But that's exactly what happened. Either he made it up or he didn't look at the evidence. The prosecutor added that the expert was full of it, and that his testimony was garbage. And the court said, while prosecutors are entitled to challenge defense experts' biases, methods, and conclusions, they may not resort to unfairly prejudicial comments denigrating the expert. The court discussed the decision in Summers, People versus Summers, S-O-M-M-E-R-S, which I'll get to in a moment. And the court said that in Summers, the court distinguished out-of-state cases holding that the prosecution denigrated the defense by insinuating that the expert concocted or colored his testimony in exchange for his fee and the prospect of future work. The Court of Appeals in Summers wrote that unlike in those cases, the prosecutor pointed out the expert's potential bias but made no prejudicial comments denigrating the expert. There was no prosecutorial misconduct upon which a claim of plain error can be based. That's a quote from Summers that appears in the McBride case. The court in McBride then went on to say that the prosecutor's repeated personal attacks on the defense expert went so far beyond accepted limits as to constitute obvious error. Those attacks denigrated the expert as a hired gun who was full of it and who in return for $275 an hour fees, which by the way overstated the actual $175 to $225 per hour fee, made up the testimony that was garbage. So that went too far. In Summers, the out-of-state cases that were cited on appeal were cases that stand for the following propositions. One of them was from Massachusetts. And in that case, the prosecutor's remarks as to the experts were based on facts, not in evidence. And the prosecution called the expert witness mercenary soldiers and prostitutes. Another case was from North Carolina, where the prosecutor apparently argued that the doctor was motivated by pay and claimed you can get a doctor to say just about anything these days. Another case was from New Jersey. There, the prosecution's closing remarks suggested that hefty fees would influence experts' testimony because they would want to be hired again by defense counsel. And there was a case from Oklahoma where clearly it was found to be clearly improper to say that defense counsel sought to bring this guy in here from Ohio, pay him to come in here to testify. He's an expert. Here's what we need to testify. Here's your 10 grand. Thank you. That was all a quote. These are all cases that were cited in Summers. The court in Summers, though, acknowledged that the prosecution is entitled to point to circumstances that raise questions about or cast doubt on a witness's testimony and may draw reasonable inferences from the evidence as to the credibility of witnesses. What the prosecutor may not do is express a personal opinion as to the credibility of witnesses or the guilt of the defendant. In Summers, during jury selection, the prosecutor made reference to the fact that the defendant would be presenting an expert who had been hired and paid by one side to testify. During cross-examination of the expert, the prosecutor elicited testimony that the expert advertised in a lawyer's magazine. The advertisements referred to a website. The expert advertised to make money, and he was being paid around $7,000 for his efforts in the case. The prosecution also presented copies of the advertisements, printed pages from the website, and a bill for the expert's services in the case. The court said a witness may be cross-examined to point out potential bias. But again, as I said a moment ago, there are limits. One of the cases cited by Summers, by the way, is People versus Taylor. That's a Colorado Supreme Court case from 1976 for the proposition that within broad limits, any evidence tending to show bias or prejudice or to show light upon the inclinations of witnesses may be permitted. The court in Summers added that cross-examining an expert about his or her fees is an acceptable way to demonstrate bias. The court concluded that unlike the cases from other jurisdictions that I listed a moment ago, not by name but by state, the prosecutor pointed out the prospect that the expert was biased because he had been paid, but the prosecution did not make any reference to the expert's pay or bias in opening statement or closing argument. The court then explained that although the prosecution impeached the expert as permitted by the law, it made no prejudicial comments denigrating the expert. Accordingly, there was no prosecutorial misconduct upon which a claim of plain error could be based. And the court in that case was reviewing for plain error. All right, with that authority in mind, let me go through the specific objections that were raised by the defense. First, Mr. King objects to a slide in each of the following pages, 14, 28, 67, and 77, because they refer to the defendant deceiving people, and the objection is based on Dominguez and Wilson. And I issued an order related to this, but I think it is important to draw a distinction between the type of situation involved in Dominguez and Wilson and the situation we have here. The situation in those cases included the defendant testifying and a prosecutor generally commenting on the character for truthfulness of the defendant and or other witnesses. That's not what we have going on here. Now, having said that, the slide on page 14 is problematic for me because it says that the defendant, it just says he deceives everyone, and he presumably is referring to the defendant, and then everyone is underlined with red. First of all, I don't think it's accurate to say that he deceives everyone. I don't think that the evidence reflects that, and so it's problematic from that point of view. It's also problematic, though, because saying he deceives everyone seems to me to be closer to a general attack on character than some of the other slides that are in question, and so I will sustain the objection with respect to that particular slide. So that particular slide should be taken out. In terms of the other slides on pages 28, 67, and 77, these are slides that Mr. Brockler has represented to the court are being used only for purposes of proving what is at the heart of the case, and that is the defendant's sanity. And of course, related to that are the culpable mental state elements of the offenses charged. So these are not gratuitous shots at the defendant's character or any kind of gratuitous character attack. This is not an attack on the defendant in general. These are specific examples of evidence that the prosecution is relying on to argue that the defendant at different points of the planning and preparation that took place in this case deceived people. And I think that goes to the element of whether he was sane or not. I don't know what else. I don't know how else you can, what other words you can use. I think deceived or mislead. And by the way, there has been evidence of this during the trial. There was evidence that the defendant took certain steps to make sure that people would not know that he was planning the shooting. Well, what is that? That's taking steps to conceal what he was doing from people, and that he did certain things to make people believe one thing when in effect he was doing something else. Well, that's the definition of deceit, isn't it? That's the definition of deceiving. So as long as it's not being used in general, but with respect to specific evidence, and as long as it is being tied to the issue of sanity and the issues related to that, including the culpable mental states, then I think it's a fair argument, and I don't know what other terminology you could use to convey the point. So the objection with respect to the slides on pages 28, 67, and 77 is overruled. The next objection, I wrote down pages 104 and 107 with respect to Drs. Hanlon and Gurr, but I don't see it on 107. I do see it on 104, so I may have misheard. Mr. King, did you say 104 and 107?
I think it was 94?
No, 104 is right. Is it 104 and 94? Is that what you're saying?
Give me one moment, Your Honor.
These are references to Dr.
87.
Oh, 87?
87, Your Honor, is the statement that the defense experts, quote, changed their practice to suit defense attorneys.
All right, and what's the statement on page 104?
It's the argument about Hanlon not contacting parents that I objected to during Dr. Hanlon's testimony. The implication being that I directed him to not interview the parents.
Which slide on 107? Is it the one that says...
That's on page 104, I believe.
Oh, 104. What slide on 104 specifically?
I gave my copy of the presentation to the court, so I don't have one here.
Here are the slides. I have it is his normal practice. The next slide is capitulated. That one is in quotes. The next slide is nothing about mental illness before April 2013. The next slide is he asked defense attorneys for it. The next slide is nothing before April 2013. And the final slide is nothing about capacity to know right from wrong before/after 2013.
So the slide would be capitulated and asked defense attorneys about it. I'm sure the argument is going to be he asked to do the interview and I told him no, and he capitulated, which is not correct. And I have no way of rebutting that statement, as I stated in my previous objection.
All right, that's in quotes. Is that something he said, capitulated? Did he say that word?
On the stand, Your Honor.
Okay.
I don't know if the court needs more, but the court will recall Mr. King, prior to this, went through a lot of, hey, you're a man of integrity, scientists, all this other stuff. You wouldn't do something that you thought, yes, yes, yes. And then when we got to this, he conceded, yes, I capitulated.
Yeah, I disagreed, I think, at the bench conference, and my position hasn't changed. As defense counsel, I don't think you get to limit an expert in how he proceeds. And I understand that it may be for strategic reasons. I get that. But I don't think you get to tell an expert, here are the limitations that you have to work within. And then when the expert testifies, to say, wait a minute, the people can't ask about those limitations that we place on him. I think it goes to his credibility, it goes to his bias, and it goes to the reliability of his opinions. I understand that you may have reasons for not wanting him to do certain things, but if he deviated from his normal practice because defense counsel asked him to, and that's what my recollection of the testimony is, and he capitulated to what defense counsel said, then I don't know how that doesn't go to his bias and to his credibility and to the reliability of his opinions.
Well, if I may, Judge, that's the issue, is that that's not what we did. We did not limit his testimony or his inquiry into the parents. He asked if we wanted him to test the parents, to give neuropsychological testing to the parents. And we said no and limited his ability to do that. We never limited his ability to talk to the parents in any way. And when my objection at the time was that I have no way of proving that is an erroneous statement, that he's making a mistake, other than testifying myself, because there's no one else who knows that information. So that's the problem, Your Honor. The problem is not that I am limiting his examination and there's a fair commentary on that. I didn't limit his examination, and I have no way to rebut that statement. That's the nature of the objection.
First of all, that's not my recollection of the testimony. My recollection of the testimony is that there were certain limitations that the defense placed and that he acquiesced. But furthermore, to the extent that he answered a question wrong, then that's on him. And an attorney can't fix that. That's on him. And so to the extent that the defense feels like the only way they can remedy this is by making themselves witnesses, well, that's because their expert apparently, according to the defense counsel, answered a question wrong, not for any other reason. But my recollection of the evidence is that there were certain things that he agreed to do or not do based on defense counsel's request. And when he was asked about that on the witness stand, that's what he testified to. And I think that's fair game because it goes to his bias, it goes to his credibility, and it goes to the reliability of his opinions. Now, if you're saying he gave wrong testimony or false testimony, then that's an issue that we can't deal with in this proceeding. That's the way it goes. If you have something to impeach him, you could have impeached him. But my recollection is that he agreed that there was one or maybe more than one thing that he wanted to do and ended up not doing, and that he capitulated at the request of defense counsel. And I understand that to the extent that any requests were made by defense counsel, it may have been as a result of strategy. But you can't, once you make that decision for strategy or other reasons, you're exposing your expert to being attacked on the witness stand, and to having his credibility called into question, and to having the reliability of his opinions also called into question. So I don't have a problem with the slides on pages 87 and 104 because I think that they accurately reflect the evidence. There's no argument with respect to that, and I don't think there's anything improper about either slide given what evidence was presented. The next one I have is impression management. And I may have taken down the pages wrong here again. I wrote down pages 123, and then the other one I have is 30, but it may be wrong. Do you know whether I got that one wrong, Mr. King?
Those are the pages I have written down, Your Honor.
And this one doesn't bother me. I mean, there was testimony, including from Dr. Gurr, that the defendant did things or said things to try to alter people's perceptions of him, experts' perceptions of him, including her. Now, her testimony was that he did it because he wanted her to think that he was less ill, mentally ill than he actually was. That was her interpretation of why he did it. But it's fair game. I mean, there has been evidence of this, whether you want to call it management of what impression other people have of you or manipulation, that came out in the testimony. So I don't have a problem with respect to those lies, and the objections as to those lies are overruled. With respect to the next ones, pages 129, 130, and 124, these are the ones that say, look how deep I am, look how philosophical I am, and look how smart I am. I do have an issue with these three slides, and the reason why is that I think that first of all, they read like the defendant testified about them, or like he said this about them, like he said this. And the defendant didn't testify. These are not quotes, so these are not things that he told anyone. This is the prosecution's interpretation of why he did certain things. The prosecution can draw inferences from the evidence, but I don't think it's fair to put it as though it's something the defendant said. So I'm sustaining the objection as to all three. You can argue that the defendant was trying to show how deep he was, or that these acts show the defendant's need to show people how philosophical he was. if those are reasonable inferences from the evidence that you're relying on as a prosecutor, I think you can say that. But I don't think it's fair to put up on a slide the statements that read as though he said them. And so the objection with respect to those slides is sustained. The next group of slides, yeah,
Your Honor, I'm sorry. May I ask for a clarification on that?
yeah.
If I simply change the language to make it clear that they're not his statements, and instead of I am, put he is, would that satisfy the court's concern?
Well, so it's going to read, look how deep he is, and look how philosophical he is, and look how smart he is.
Yes, sir.
I think that's different, and I think if those are reasonable inferences from the evidence, I think those are different for me. So, but just saying them the way that they appear right now is problematic for me. The next group are the slides that appear at pages 36 through 43, 45, 34, 50, 52, 53, 54, and 57. And the objection with respect to all of them is that these are statements by the defendant to different experts, and that the prosecution is using them improperly to establish his guilt, not his sanity. To the extent that these were made to an expert witness, I told the jury that the jury could only consider these statements for the limited purpose of the issues raised by the not guilty by reason of insanity plea. Mr. Brockler is representing to the court that that's not how he's using them, that he's not using them. When I say that that's not how he's using them, I mean that he's not using them as the defense is arguing he is. He's saying, as an advocate of the court, that he's going to use them for the limited purpose for which the court introduced them. And as long, Mr. Brockler, as you're clear about that, and they are specific, then I overrule the objections. I will note that many of these have the actual language about after deliberation or the actual language about part of the definition of deliberation in there. And so I'm assuming that they're going to go exactly to the issues for which these statements were admitted, but you have to be very careful about that.
But could the court would also note from these that I've also, where those quotes are taken from a mental health expert for sanity, I've put that mental health expert's name there. And the point of that was to highlight for the court and for the jury, again, that statements made to the mental health professionals are only available to them for purposes of determining issues from the not guilty by reason of insanity plea. They don't just hang out there on their own.
Okay, and if you want to clarify that for the jury as well in terms of reminding them that this evidence was introduced for the limited purpose of the issues raised by the not guilty by reason of insanity plea, that's even better, that's even cleaner. I just want to make sure the jury's not left with the wrong impression. So the objections are overruled with that caveat. The next one is
Judge, if I could, I would just say that that limiting instruction also pertains to the notebook. Many of those slides talk about statements that are made in the notebook, and they're talking about planning and different aspects of how he conducted himself in the theater and prior to that. And I think it needs to be made clear, if that's the argument, that they relate only to sanity.
Yes, I thank you for reminding me. There were some of those slides that are taken from the notebook. Again, it appears from just my review of the slides that Mr. Brockler is using them for the limited purpose for which the notebook was admitting, but you have to be careful again to make that clear to the jury. One thing about these slides before I move on, there were a few slides that have red underlining, and I know you're simply trying to highlight some portions of the slides, but you know the slides were not admitted with any red underlining. I don't have a problem with the fact that the font is larger because that was done by both sides here in the courtroom, but putting red underlining in exhibits that did not have red underlining when they were admitted, I think is problematic, and so those red underlines should be deleted. There are only a handful of them, but I noticed that there were a handful of exhibits that have that red underlining in them, and so based on the Glassman case that I read, I think it's appropriate to have those underlines deleted. The next one is about the kill suit on page 84, and this is argument. That's the people's argument in terms of what description of the suit. This is the armor that the defendant put on before he went to the theater to commit the shooting. That evidence is undisputed, and I don't think that it only comes up in one slide, and it is referred to as a kill suit. And again, given that this is argument, I don't have a problem with that. So the objection is overruled as to that specific slide. The next one is the slide that says on page 93, prosecutors seek justice for those who are wrong. I think the objection was based on how the case law says that it is improper for a prosecutor to tell the jury that he's doing things for victims or to obtain justice. But I think that's taking it out of context. My understanding of the context of that slide is that Mr. Brockler is using it to show the defendant's capacity or evidence of the defendant's capacity to distinguish right from wrong. And he highlighted the word wrong, in fact. Am I right about that, Mr. Brockler?
That's correct.
Okay, so the objection as to that slide is overruled. The next one has to do with manufactured, and it has to do with Dr. Gurr, and apparently what Mr. Brockler referred to as manufacturing a quote. The problem I have with this slide is the slide is taken out of context. It just says manufacturer, Dr. Gurr. It's on page 109. You know, if you want to say that she took portions from two different quotes and came up with and then combined them both and came up with her own quote in her report, I think that's fine. That's part of what came out in the evidence. But to just have a slide that says Dr. Raquel Gurr and then below it manufactured, I have a problem with. So I will sustain the objection. That's based in part on the case law that I cited earlier from McBride and Summers. The final one is page 119, and this is the reference to collateral damage. And Mr. Brockler argued that he's not going to use collateral damage in the context of guilt, but rather in the context of the issues raised by the not guilty by reason of insanity plea. The problem with this particular slide, however, is that on the same page, there is a name, Caleb Medley. The name Farah Sudani is in another slide, and that's the only name that appears in the slide is Caleb Medley. And in another slide, the only name is Farah Sudani. Then there is a picture of, I believe it's Farah Sudani in her injury in one slide, and then it says Dr. William Reed, plus 58, plus page report. I think the way that this is set up, it is problematic because it is specifically referring to the injuries. It is connecting the injuries that some of the victims incurred and the term collateral damage. And that's problematic for me, so the objection with respect to that particular slide is sustained. In terms of the global objection, I think I've addressed all of the objections. I think that the global objection is to PowerPoint presentations in general. The defense, it's my understanding, is using part of a PowerPoint too, and the defense used a PowerPoint presentation with a couple of experts, at least one expert witness. I think it was Dr. Gurr, and maybe there may have been a PowerPoint presentation with respect to another expert. I can't remember now. It may have been with respect to Dr. Hanlon. So PowerPoint presentations and visual aids have become more and more popular in trials. The reason is the lawyers realize what experts in the field have said, and that is that visual aids can help the jury understand things better or remember things better. But that is also part of the reason why you have to be careful with them, and that's why I'm trying to be, in addressing all the specific objections, I'm trying to be as careful as I can in following the law and setting the parameters that I think are appropriate. Now, I want to make sure I caution the prosecution that to be careful to avoid opinions. Obviously, a prosecutor is not allowed to have his own opinion expressed to the jury in closing argument. It has to be based on the evidence and reasonable inferences raised from the evidence. You're allowed to make argument. You're not allowed to interject your opinions about the evidence. So that's number one. Number two, you have to be careful not to confuse arguments with the evidence and not to mislead the jury. I'm not saying that Mr. Brockler would intentionally mislead the jury, but even if you don't intend to do that, you have to be careful not to do that. And so be as careful as you can, Mr. Brockler, when using your PowerPoint presentation so that it is clear when you're referring to evidence, for example, if it's in quotation marks, and when you're not referring to evidence and you're referring to argument. I just don't want the jury to be misled in any way. And then I have talked about the exhibits that need to be modified already. Given those cautionary remarks, the global objection to the PowerPoint presentation is overruled because I think in general PowerPoint presentations, as I said, are appropriate. I'm not aware of any rule that says that you're not allowed to have slides that contain sort of an outline, if you will, or that contain a few words to remind you as you're making your way through closing argument what your next point is. This is a closing argument for each side that is 2 hours long. I have given each side 2 hours long, and it is difficult to make a 2-hour closing argument even when you're splitting the 2 hours into opening closing argument and rebuttal closing argument. It is difficult to do a 2-hour closing argument without some kind of outline or some kind of aid, and I don't think there's anything improper with respect to using the PowerPoint presentation as an outline to guide you through your presentation. As I said, my understanding is the defense is doing some of that too. The defense did that with Dr. Gurr as well. So just be careful to make sure you stay within the legal parameters. Is there anything else at this time before we break for a short lunch?
May I ask for some clarification on 2 points, Your Honor?
Yes.
Back to the 109, which was the slide regarding Dr. Gurr, where I had put manufactured in between 2 slides setting out her quote from her report and then what the real quote was from her notes. Would it resolve the court's concern to put manufactured quote as opposed to just manufactured? And Judge, I totally get where you're going. In isolation, it doesn't make any sense. But in the context of talking about it, it's to say, this quote here, it was manufactured. She put it together out of 2 other quotes, and that's what I sort of go to do. So I don't want to step on the court at all. I just want to make sure I understand.
Does the defense have a position on that? Mr. King, you haven't been heard on that, so I'll give you a chance.
I would maintain my objection, Judge. It isn't manufactured. That's incorrect. What apparently happened was there were 2 different quotes, and she just combined them into one quote in her report. They're still quotes. They're not things she made up or manufactured. They're evidence in the case. And if he wants to comment on how she wrote it in her report, that's fine, but they're not manufactured.
I'll sustain the objection. It causes me concern to have the word manufacture on a slide. I think, as I said, Mr. Brockler, it's fair game for you to argue and remind the jury. And the jury, this is a smart jury. They remember things. They will remember, and they will remember the exchange. And you can tell them she took 2 quotations, 2 quotes, she put them together, and your argument is, and you asked her about it, is that this then meant something different than what was said. I think that's fair. I think to say manufacture, especially in a slide, given how careful appellate courts want trial courts to be when it comes to using words such as manufacture, as it relates, when it comes to using words such as lie, when it comes to witnesses, I want to be careful about that. And so I'm going to err on the side of caution and sustain that objection. So that objection is sustained. Anything else? Any other clarification that you wanted, Mr. Brockler?
Well, on that one, would inaccurate be fair?
Inaccurate is fair, yeah. You can say inaccurate.
On the collateral damage one, Your Honor, just to be clear, that I understand the court's ruling on it. Right.
And hold on, sorry. If you say inaccurate, I'm assuming you're going to say inaccurate quote.
Yes, sir.
Okay, I think that's fair.
On the collateral damage slide on page 119, it follows the video clip of him talking about collateral damage and how he viewed the non-deceased victims he created. Is that out as well? Take both those things out, given their proximity to the other victims?
Yes. Yes. What concerns me is connecting the 2. I know what you're trying to do, and if there is a sentencing phase, perhaps this is fair for that. I don't know. I'm not ruling on that, so don't quote me on that. I'm just saying that it doesn't, to connect it to say, well, he referred to these injured victims as collateral damage, and then show the jury, here's what he thinks is collateral damage. That's what's, I think, could be very prejudicial, and it doesn't go to the issues raised by the not guilty by reason of insanity plea.
If I separate them, does that resolve the court's concern if I
Yes.
have some disconnection?
Yes. As long as that connection is not made in any way, then that takes care of it. All right, Mr. King, here are your slides. Thank you. All right, how long do you need for a lunch break, folks?
I have no preference on the lunch break. Can we make that a court exhibit, Your Honor, the original of the PowerPoint, please?
Yes. Do you want this copy back right now, though?
Sure, I'll
All
do
right.
that.
Why don't we mark it later, if it's okay with you? That way you can have it for now. Thank you. All right, is it okay if we take 15 minutes? Is that okay with everyone? Does that give everyone a chance? Okay, let's take 15 minutes. The court will be in recess. Thank you.